class number, if I'm correct, 15?
Mm-hmm.
This is actually not class 15. It is technically 16, but this is video 15 because we had to skip last session, and hopefully you got the assignment. You did? Okay, we should all be good on that. That's good. You're supposed to have like an essay every other week, and by essay, you know, those little reading things and who, what, where, when, why kind of things. Trying to do that a little bit and throw your quizzes in there. We're going to be midterming it pretty soon, so don't worry about that. I'll let you know. And you guys all took the other quiz that was popped up. Okay, how'd you do on that?
Way better than I did on the first.
You did a lot better on that one. Good, good. Remember, these are open source. You can use your notes on these. I mean, I'm not going to sit there and go get your Lockdown browser and all that stuff. You know, the nature of the way this is this semester, we gotta. And by the way, in life, researchers research. It's not all about memory. It's about, hey, how do I go find the answer? Okay, so you're still good with that. I don't have a problem with that. So we're good. All right, I think things are happening, and we're building grades, and that's what I like. Okay. Today we're going to talk about the judicial branch of government. We had just finished Congress, and it's very appropriate because right now two things have happened. There's confirmation of Amy Coney Barrett that's coming up, and she had just gone through her hearings in the Judiciary Committee. Did you guys pay attention to that? Did you watch any of it? No, you watched a little of it? What'd you get out of it?
I really didn't catch much because it was like I was trying to like interpret what they were saying, but I was also like, hey, I need to watch the full thing again.
Well, it's very long. It's they ask her a lot of questions, and depending on the goals of the committee. I mean, there were senators. Those are the ones who are going to confirm her, right? They vote to confirm her. And at this point, all they need is a simple majority. And so the Republicans have it. They have that majority. They cannot vote her down, okay? The Democrats will not win. Why do the Democrats not want her to win? Become nominated. It's not a winning. She's not in an election. But it is kind of, in the sense of these guys are confirming her. What is it? Now, she didn't run. She was, selected by the president, right? Nominated. What did you say up there?
They don't want her to be selected because she's more on the conservative side.
There's two things going on with her. Well, first of all, if she is, right, it's very political right now. So any judge that is appointed successfully by the president is seen as a victory, and he can claim that as a victory. And in politics, when you're running for office, you often say that phrase, promises made, promises kept. And he promised his constituents he would put conservative judges on the bench, and this would be his third, that is a lot, third on the Supreme Court, and he has basically filled the court system with conservative judges. Now, what do I mean by conservative judges? By conservative, there are two approaches to the law, okay, to the Constitution from the judicial branch. One is, and this is very testable too, also, is an approach called the living Constitution, okay? And you hear people say the Constitution is a living, breathing document. No, it is not. It is a piece of paper and ink. Now, if you're talking about the meaning of it, then, well, that's a very philosophical statement. And the answer, again, I would argue, is no, it is not. Okay? But you can treat it that way. And people do treat it that way. As though the Constitution can mean many things and apply to many things that are not specifically stated by the words in the Constitution. That it could mean many things, and it could apply to many things, that are not specifically stated in the Constitution. You got all that? That it could mean many things and apply to many things that are not specifically stated in the Constitution. All right? That you could apply the different amendments, like freedom of speech, freedom of religion, right to bear arms, all that stuff, to other things that it does not specifically state. Okay, and you could use those words and interpret them in such a way that does not line up with the way they were originally intended to mean, but given our cultural situation, you can apply them now. That's the living constitutional approach. Judges who take this approach are often called activist judges. And the goal of the activist judge is to make use of the Constitution to often right wrongs or right injustices. Their goal is not to interpret the Constitution as it is written. It is to right wrongs or make just injustices. As they perceive, by the way. As they perceive. Which can be quite arbitrary. And they could come up with all sorts of different conclusions using the Constitution that are not in the Constitution. Now, it sounds like I'm giving it a bad rap. And I am. The problem with it is that the Constitution can mean anything, it doesn't mean anything. If it can mean everything, it doesn't mean anything. Why have a Constitution if you're not going to interpret it as it is written? If you got a problem with the Constitution, you tell them as a textualist, okay? If you have a problem with the Constitution, change the Constitution. But what is the problem with that?
Takes a while.
It's very hard to change. It's very hard to amend the Constitution. But it's not hard if you get your judges in who say, well, I'll just interpret it the way you want it to be interpreted. That's easier. And that's why the Democrats want right now, they're really upset about this woman being on the court because she is not a living constitutionalist. She is what's called a strict constitutionalist or a textualist. Okay? A strict constitutionalist, or it's also called originalist. A textualist, an originalist, all right? And the idea behind this is you interpret the Constitution as it is written. You do not interpret it in light of the cultural shift. So if the culture shifted again towards, say, slavery, you wouldn't start reinterpreting the Constitution to allow it, right? You would say, no, the Constitution forbids it, explicitly forbids it. You would go by what the words say, and you wouldn't interpret them as to what you hope they say or want them to say. In fact, the problem, and here's the problem with the originalist position, sometimes the case is not going to end up the way we want it to end up because the text doesn't allow it. Because it's not about what I want the text to say, it's about what the text actually says. And thus, to my dismay, I may have to, as a judge, say, look, I don't like it as much as anybody else. It may seem unjust this way, but if you want to change this, you better change the Constitution because the Constitution says this. Okay? And so the textualist is going to say, for good or bad, or for desire or undesirable, I am going to interpret the Constitution as it is written. I shall judge that which comes to it against the Constitution. And we'll see where that stands. We'll let the chips fall where they may. Now, Amy Coney Barrett is a strict constitutionalist, and they don't like that. One of the reasons they don't like it is they're afraid Roe versus Wade is going to be overturned. And why do they think she would specifically overturn it? One, because she's a Catholic.
Okay.
And she's not just a Catholic. She's a Catholic who actually believes it. Okay? And I'm not to judge Joe Biden, but here it comes. Or Nancy Pelosi, who are both Catholics. But they don't believe the doctrine of Catholicism concerning life. And that abortion is an abomination. They're like, we don't follow that one. Or this thing with same-sex marriage. They're like, whatever. So you get Amy Coney Barrett believes it, and they're like, when Feinstein said the dogma lives loudly within you, she's saying you are a real Catholic, and I'm afraid that and she said, and that is a problem. Go ahead. What's your question?
What do you mean by Roe versus Wade?
Roe versus Wade is a landmark case that made abortion legal in all 50 states. Okay, I think her name was Linda McCorvey. Said she was raped, and she was seeking an abortion, and they took the case and it got all the way up to the Supreme Court, and they used her as a poster child. That was her name, and they changed it to Jane Roe, right, for anonymity. She actually never got the abortion, and she also, admitted to lying. She wasn't actually raped, okay? Later on, she said she became a Christian, but then later on she said she lied about that. So she's a real questionable character to begin with, okay? But the case itself made abortion legal in all, 50 states, and it was based off the idea of privacy, okay? Now you see, there's nowhere in the Constitution that mentions abortion. So they apply this idea of somehow a right to privacy gives you a right to an abortion. Now, since then, many legal theorists have said that was horribly decided. They may believe that abortion should be legal, but they believe that the way they did it was horrible. That it was poorly decided in the court. That they made poor use of the Constitution. And so later on, Planned Parenthood versus Casey, though, confirmed woman's legal right to an abortion. I make a distinction between the legal right to abortion and natural right to abortion. We have the natural right to life, liberty, and pursuit of happiness, correct? Do you have a natural right that is endowed by God? Remember what we talked about, what natural rights were? Do you have a natural right? Are you endowed by God to kill children? No, that would seem odd, okay? No. But then people go, well, you're not pregnant with a child, you're pregnant with a fetus. Well, the word fetus is child in Latin, okay? So you can change the word, but you can't change the word doesn't change the nature of something. Just like I could call you, sir, you're black, and I could call you 3/5 of a person. That doesn't change that you're a real person or a real human, does it? And that's why the 3/5 compromise was a load of garbage, wasn't it? Because it was false. No matter, you could rename something all you want, but if, a human's a human, no matter what I call them. Anyway, so you know my opinion on that. So this is a big deal. And so people are afraid and people are hopeful. The pro-life movement is hopeful that a case will come before this court and that Roe versus Wade will be overturned. And what will happen is it will not make abortion illegal. What it will do is they'll kick it down to the states. And what's that?
So they can decide?
So the states can decide. So if Texas passes a law that forbids abortion and gets that abomination off of, I think it's 59, that's the nation's largest abortion clinic, Planned Parenthood right down by UH. Have you seen it?
Yeah.
Two.
I've been
You've been there?
there. Yeah.
Oh, I don't know. Anyway, they make that illegal. They get, that would be the states, okay? And the federal government wouldn't step in. So Colorado could be a pro-choice state. Texas could be a pro-life state. And you would make state laws on this. And this is still, again, this is a battle between federalism, okay? Your federalism is states' rights versus the federal, okay? All right, moving forward. So the court is very important to all of this. Now, by the way, this is, this goes with Obergefell v. Hodges too. What is that? That was the same-sex union, same-sex marriage case. What was the problem there?
You said
Well, states were denying marriage certificates and licenses to same-sex couples. And this gets taken up by the Supreme Court, and allegedly this is now a violation of their civil rights. Okay, and thus once the court, remember I've given you two versions of the court views of judicial theory, right? Constitutional theory, interpretation, I should say. You've got the living Constitution and the textuals. Where in the Constitution does it even mention the word marriage? Right. And so, all the states, in Prop 8 in California had forbid same-sex. Even in California, it lost. A very liberal place, right? Never gonna vote Republican. When I say never, that never's a long time, but still. They struck down same-sex marriage. So what do you do when you cannot get the votes? You take it to court, because if you can convince the court, 9 people, 5, all you gotta do is convince 5 out of 9, the majority, right? You don't have to convince millions of your fellow citizens, or the majority of Congress in both houses, chambers I should say. All you gotta do is 5 people. And you can change a law. Or you strike it down as unconstitutional, right? A violation of your civil rights. So the courts become very, very important. Right now, they are very important because it's a very powerful thing to do this. Now, in our presidential election, what has been threatened by the Democratic Party?
Aren't they trying to stop the election of her?
Well, they're trying to stop it. That's not going to happen. They're going to get it done. So they're going to be in the minority. They're going to have originalists, 5 originalists it'll be 6 originalists to 3 living constitutionalists. Okay. Sotomayor, Elena Kagan, and can't remember the third. It might be Breyer. But you'll have 3 textualists, 3 living constitutionalists to the rest of them originalists, which tips the balance of power greatly. And that means that the Democrats who cannot convince the rest of the population to go their way, right, cannot take it. They can't count on the court anymore to enforce their will if they cannot get it passed through the legislative branch, okay? And that's bad. So what did they say they're going to do? They said this is what we're going to do. If we get if we get the presidency and if we get the Senate, what we're going to do, of course they have to keep the House. What we're going to do is we're going to end the filibuster. We're going to, which helps people stop legislation. That helps the minority party, okay, keep from being overrun. And they're going to vote in a couple of things. What they're going to do is they're going to vote to confirm, it's called court packing, 3 more justices, so that they can pack the court with 3 more living constitutionalists so that they can still use the court, right? After that, what they're going to do is admit Puerto Rico, and I've even got some literature on that. They're going to admit Puerto Rico as a state, turn DC into a state, and so they're going to create at least 2 more states, Puerto Rico and DC, which will add how many senators? 4 senators, which will give them a very big majority in the Senate, so passing legislation will be a lot easier for them, right? And confirming all these justices will be a lot easier for them, because if they confirm, why would they go DC? Why would they say DC in Puerto Rico? Because they've already done the math, and they know that those states are or at least DC is very, very democratic, okay, very liberal, and so too is Puerto Rico, and so they know that any senators that they would put out there would end up being Democrats, okay? So this is a power grab, right? And they're saying if you win, which the Republicans have done, they have the presidency at least for right now, and they've gotten the majority textualists originalists on the court, and so they're like, if you do this, we're going to pack the court. Now the big thing is they're asking Joe Biden, are you going to do this? Are you going to do this? He's like, I'm not going to tell you what I'm going to do. I'm not going to tell you. And so, but everybody knows if they get into power, that's what they hope to do. Okay. Whether or not that happens, I don't know. Okay, but the judicial branch, you can see how powerful it is. Now, interestingly enough, it was not meant to be that way. In the Constitution, it is a third branch of government that is discussed. And it goes in order of what was supposed to be the most powerful. What should be the most powerful branch? It's the one that was mentioned first.
Legislative.
The legislative branch. And the second one was the executive branch. And then the third one was the judicial branch, all right? So anyway, let's talk a little bit about the judicial branch. I want you to read the Article 3, obviously, if you have not done so yet. We have 2 types of court system. Well, we don't, but there are 2 types of court system. One type of court system is what we have, and that's called the adversarial type of court system. That's not in the Constitution, but I want you to read it, okay? Because the contents we're going to discuss are going to be in it. The second kind of court system is the inquisitorial system, okay, or the inquisitional. Called the inquisitional. So you've got the adversarial, and you got the inquisitional. The adversarial is you've got the prosecutor, you've got essentially the accuser, right, the one prosecuting the case, who collects the evidence, and then you've got the defendant. In the middle, you have this judge who is a referee sometimes, and sometimes the jury as well. Sometimes. In the case of the Supreme Court, they end up being the jury. All right? Usually in federal appellate courts, they are. All right. So in that case, you will be, let's say there's a crime committed, and the prosecutor will indict you. And what they do is by indicting you, they have made formal charges or accusations against you. And you are going to go to court now, and you are going to defend yourselves against these accusations. In the adversarial type of court case, you're going to have what's called the neutral party, which is the jury, right? The jury's going to be allegedly neutral, coming in with no knowledge of the case, coming in with no knowledge of the facts. They're going to be brought before them, and they're going to be, unquote, unbiased, right? And there's a method by which they choose juries, and they could get very complex depending on the case, okay? In an adversarial case, the accuser, the prosecutor presents their case. They call their witnesses, And the goal is to win the case for the prosecutor, to get the conviction, to convict of the strongest crime you could accuse him of. Right? So sometimes, they'll go, okay, this person committed first degree murder, but I'm not going to be able to prove that. I don't have the evidence. So I don't want to overcharge them, because if they get off on first degree murder, they're off. Right? So you charge them with second degree murder, right? It's easier to get. Okay? You don't need to prove malice and forethought. You just need to prove that the guy killed him, intentionally. Second degree murder, okay, at least we got the guy, okay. Well, they present their case, and then the defense comes in and just tears apart the case and pokes holes in it. And the idea is that the accuser, or the accused, I should say, is innocent until proven guilty, right? And in America, we have due process. That is, you have guaranteed due process. If you are charged with a crime, they have to prove it. It is the government's duty to prove that you are guilty. It is not your duty to prove that you are innocent. Do you understand that? And that's why the charge, when found not guilty, is not guilty, not innocent. They don't say you are innocent, they are said that you are said to be found not guilty. Because all that's saying is the prosecutors failed to prove that you are guilty. You understand that? So the adversarial, you have two sides fighting, and one side's trying to prove your guilt, and the other side's just trying to show that you were not adequate in showing it. Okay? This is in contrast with the inquisitional model. With the inquisitional model, unlike the adversarial, where victory is what you're looking for, the truth is, and I know I'm going to make it sound like this is better, okay? I don't know if it is. This is what they have in France, okay? The judges do the work. The judges do the investigatory work. The judges render judgment based upon the evidence. So it is incumbent upon the judges to be fair, that they are actually gathering the evidence to see if the crime that has been accused, or the accused is guilty of the crime. And so they do that, and they look at the evidence. They try to be unbiased. Now, and they will question people. What do you think? Which one would you rather go to? Which one would you rather be brought before? Let's say somebody, you got a charge. Would you rather go to court in France under the inquisitional model, or would you rather go on say, the American model, which is the adversarial?
American model.
Why is that?
Actually, never mind. I'd rather go to France.
What's that?
I'd rather go to France because the prosecutor tends to win in the adversarial, right?
So France, the judges are doing the work, right? And they're more looking into it. It's an inquisition. Inquisition sounds bad, because remember, you think of the term, Inquisition. They talk about the Spanish Inquisition, and they call it the Leyenda Negra. What was it called? The Black Legend of the Spanish Inquisition, right? And so this idea that they're torturing people, right? Well, that's not quite what it is. The word inquisition just means to look into, all right? And so the question is, would you rather have a judge look into the case? I mean, I guess it depends on your guilt or innocence, right?
Yeah.
I mean, if they're looking for the truth, you might want to escape that. You're like, I know I did it. I was like, if you ever watch the Pink Panther movies, it's all
Does it sound
free.
like
Yes. Yeah, they're investigating. Yeah, it's kind of the way it works, right? They have to look at the evidence. They assess the evidence. They determine they determine what the evidence says, and if there is guilt or non-guilt, if there's a crime or a non-crime. Okay, the prosecutors in the adversarial bring the case and they say, we have indicted this person. How does one get indicted? First, to be indicted, you go before a grand jury. A grand jury is a panel of people, and they're presented with a case, and the prosecutor brings the facts of the case to the grand jury. Okay, and this jury just looks at the case and they say, by majority, okay, I think you need 8 out of 12 or something like that. Please forgive me if I don't have it correct. I think it's 8 out of 12. I'll look it up. But if you convince 8 out of 12 of the grand jury, it will go to court. That doesn't mean the person is guilty. It just means the prosecutor has enough evidence to bring a case against somebody. Does that make sense? And so you are indicted if you're indicted by a grand jury, it shows that there is a certain number of people on that jury who decided there's enough evidence to bring a charge against whomever. Go ahead.
What's a pre-trial?
What is a pre-trial? Well, during the pre-trial, they'll do certain things. One of the things they'll do is select jury. So selecting the jury, you bring in a bunch of people, and the both sides will get questioned. Prosecutor will come up and ask you any questions. Have you heard of so and so? What's your thoughts on the death penalty? Have you ever had anybody killed in this manner before, or killed at all? Right? And then and you answer a certain way, and he goes, "Okay, we'll keep her." And then the defense attorney comes up and starts asking certain questions. So, what's your thoughts about the death penalty? And stuff like that. And you're like, "Oh, I love it. I'm all for it. Let's go kill him." And he's like, "Yeah, we're gonna release her." And so the idea is to try to get, during pre-trial, you try to do stuff like that, and that's one of the things you do. And so you can, what you do is, jury selection's great. All right. All right, do you guys understand the difference, at least in a vague sense, of what the adversarial versus the inquisitional models are? Go ahead.
Does the judge ask the guilty party of the inquisitional?
You mean the accused party?
Yeah, accused party.
I don't know if I'd want to be, if you were my judge, you're the guilty party. Will the guilty party please come forward? No, go ahead.
Does the judge talk to the accused on the
Yes.
inquisitional?
Sure, yeah. Yeah, they'll question them. Absolutely. America, we're very focused on the protection of rights of the accused. And I kind of like that. Not as much care about the truth. You're worried about the protection of rights. Okay? And we know that there are a lot of people in jail who have been falsely accused. And so even in America, our rights are not always, we do our best, but we're not perfect. And that's why there was such a big deal over prison reform and all. Some judges have actually over-sentenced people. All right, wait, so there are two types of courts. One is trial and one is appellate. Okay? Trial courts will deal with criminal prosecutions and civil cases. Yes, trial courts will deal with criminal prosecutions and civil cases. So there are two types of courts, trial and appellate. Let's see if we got the marker. If I do, I'll put it on the board. So you got the courts, two types. Trial, and you got appellate. Let's see if I could misspell it. Probably did. Let's see. I knew it. 2 P's. All right. So with the trial, you get two types of cases: criminal, and then you got civil. criminal court seems to be the fun one. I mean, if you know, when you think of going to court, most often people think of, you know, you're charged with murder, you're charged with theft, you know, all the cases. If you ever watch those TV court shows, you know, where they, you know, the two lawyers and they're like, you know, fighting over the big case and all that, right? That's criminal court. You know, the guy's guilty of murder, Perry Mason. Did you do it? I know you did it. And he's like, yeah, I did it, you know, or whatever. Criminal case. Never happens that way. It's generally a lot different. Civil court. What is civil court? What is a civil case? I mean, you've gone to court before. Has anybody in here gone to court before? You will. One day you will. Every day, everybody's gonna find their day in court. You've been in court?
Yeah.
What was it? Was it a civil case?
No.
You don't know if it was a civil, I'll tell
It
you.
wasn't criminal, like,
Well, then it was civil.
well, yeah, I guess.
I mean, is it personal?
No.
Look at mom and dad go to court, they're fighting over the kids. Is that a criminal case?
No.
What is it?
Civil.
Civil, okay, cool.
It was my license plate. I had just got my car and it wasn't on the front because you need to like screw it and get like a.
Oh, yeah, that's
thing.
criminal.
Yeah, with us.
Breaking the law. No, it is in a sense, you know, those court those are infractions, like speeding tickets is, you know, that's not a civil case, but it's also not, I mean, it's not like, we're not gonna make a movie out of it, true crime. You know, she didn't put her license plate on properly. I knew you did it, you know. So yeah, well, so civil, you know, you're gonna find a lot of cases, you know, where you got, it's not criminal, but the court has to make judgments on it. So you bring your case and, you know, and you've got the defendant, okay? It's not a crime, but you will lose, or win, okay? Most often, both parties lose, okay? And that's the problem with going to court, all right? So, all right. Handy dandy clipboard. Appellate courts, all right? On the other hand, those are going to review errors. The appellate court assumes that not every court decision was decided correctly. So the appellate court can review court cases. You can appeal a court case, a decision, all right, made by a lower court. So there are two types: trial, which does criminal and civil, right? And then there are appellate courts. Now, America has, the cool thing is, we have a dual court system. A dual court system. We have the federal court system, which deals with federal laws. And we have the state court system. We'll talk more about the state court system here in a second. Is it a federal crime? Which court do you think you'll go to if you evade your federal income taxes? That's a hint right there. Think you go to a federal, or do you think you'd go to a state court for that one?
Federal.
So they deal with their own jurisdiction, okay? Whatever crime or law that is dealt with will go to the appropriate court in its appropriate jurisdiction, be it federal or state, all right? In the federal court system, I'm just gonna read this. I'm not gonna really, I'm not saying I'm not gonna test you on this. What I'm gonna tell you is I'm not gonna walk up to you and expect you to answer this. although it'd be pretty cool if you did know it, that there are 94 district courts, 4 of which are in the great state of Texas. How many district courts are there?
94.
94. And how many of those are in the great state of Texas? 4. All right? So the 50 states, the other 49 states have to divide up the rest of the 90, okay? There are 13 U.S. courts of appeals. Texas is in the 5th, okay? Called the 5th Circuit. You got the 9th Circuit Court, which is the West Coast. And that is by far the most judicially active court in the land. What do I mean by that? I mean, they are judicial activists, they are living constitutionalists, right? And they use their power specifically, to right the wrongs that they believe have occurred. And they will, that's why when you see the president losing all these court cases, right, in the federal courts of appeals, these district courts, or these courts of appeals, I apologize, it's often in the 9th Circuit. Why is it on the 9th Circuit? Well, because what they do is they bring the case to where it will, if you're gonna bring a case, you're gonna bring it to, and you want them to judge in your favor, or you go judge shopping, basically. Are you gonna go to the Texas courts of appeals in the 5th Circuit, where they're going to be strict constitutionalists, and they're gonna say, sorry, the Constitution just doesn't talk about same-sex marriage? Or are you gonna go to the 9th Circuit Court? Where are you gonna go? You're gonna go to where you're gonna get the answer you want to be given. And so people, what they do is they actually do what are called test cases, where they will sue or bring a lawsuit, and they bring it in a district where they know it could reach the Court of Appeals of their desire, of their choice, so that they could get the desired outcome. Now, it's a very cynical way to look at it. And I'm gonna leave it at that, because I don't like it. I don't think that's right to do that. Because obviously I think we should go through the legislative branch to do this. But that's the way it's done, okay? So anyway, we have 94 district courts, 4 of which are in the great state of Texas, 13 U.S. courts of appeals, and Texas is in the 5th. Which one is Texas in?
5th.
The 5th. And I mentioned the 9th, okay? President Trump has added a couple judges because I think they retired or something. And so he put a couple more in the 9th Circuit Court, which really upset them, because he put constitutionalists on there and they're like, what are you doing, you know? Now there is, by the way, a rule, and it's unspoken, okay, that the senators in those states usually will kind of help him decide on who he is going to nominate, right? If they're all playing friendly. But the senators of California, who are they? Who? Yeah, they are Democrats, but who are they? Feinstein and Kamala Harris, okay, are not very nice to Donald Trump. So he just, I want to say foregoed, forewent. He didn't consult them when he nominated judges to the 9th Circuit. And they were really upset about that. But why should they, you know, they're going to be upset at him no matter what he does. Okay, so he's in a no-win situation, so he just gave him the middle finger, presidential middle finger. All right, so 13th U.S. Courts of Appeals, Texas in the 5th, and 1 Supreme Court of the land, and currently there are how many members on this Supreme Court? 9. Why is it important to have an odd number?
Majority rule.
Majority. All right, so Grant Certiorari that is that they're gonna hear the case, okay? There's this thing called the Rule of 4. Write this down, the Rule of 4. So for the Supreme Court to hear a case, hear arguments for the case, a case must come before them, and 4 of the 9 must decide that it is worth even hearing. Okay? It's called the Rule of 4. And if you get the Rule of 4, then they will hear the arguments for the case. And the goal at that point is to convince at least 5 of the 9. How many members are on the court right now, I say? What?
8?
8. Why?
Um,
Because Ruth Bader Ginsburg died.
yeah.
And we're in a confirmation process of confirming Amy Coney Barrett. Recently, a court case, I think it was concerning Pennsylvania, came down, and it was actually, I don't know what the number was, it was decided, that they will be able to count votes up to 3 days after the election if you get your vote will count if you get it in and it's postmarked on the day of the election, so I can mail my ballot on the day of the election and get postmarked, right? As long as that's the case and it gets in, 3 days later they'll still count it. So November 3rd is the date of the election, right? When do you usually get the results of the presidential election? What? The day of the election, right? We like to know who's going to be the president on the day of the election. Usually we're all voting, polls close, usually, once the polls close, you're like, okay. Then you're watching the states roll in and you're seeing who's going to win, right? And by the end of the night, sometimes you're up until midnight and you're waiting for that, and there you're all sitting around your TV, who's going to be the next, probably not. The teenagers, up to you guys up to now probably were like, what's happening? Right? But generally, those who vote like to see who's going to be the president, okay? In Bush v. Gore, I say Bush versus Gore, it took a long time because there were some problems reading the ballots in Dade County, Florida. Apparently those guys don't know how to punch a ticket too well, and they had these things called hanging chads, and they didn't know it was going towards Gore or if it was going towards Bush. And it ended up they recounted and it went to Bush. And they recounted again and it went to Bush. And they kept wanting to recount it, maybe hoping for a different outcome. And finally they brought it to the Supreme Court, Bush v. Gore, and the Supreme Court said, you cannot keep recounting it, it's done. And Bush won the election. Okay? Now you can see why the Supreme Court is going to be very important. Because what if you have a 4-4 vote in the Supreme Court over the President of the United States?
Then you have that one person who can go.
Well, if we only have 8, that's why we need one more in there. And that's why Amy Coney Barrett is important to get on there. Not that she'd vote for Trump. I mean, and by the way, that just shows the view of the court as though it is a legislative body that if we only need to convince 5 people, we get our will done, right? Rather than 5 people agreeing that the Constitution says this. Do you see the difference? Rather than people voting their will, they vote what the Constitution actually says. And they're not even voting like I want it to say, they're confirming it. It's an interpretive thing. Because you can be wrong in your interpretation. Unless the Constitution can mean anything you want it, then you can't be wrong. All right. State court systems. There are 50 state trial courts. Makes sense? There are 50 states. There are 40 state courts of appeal. Some states don't have courts of appeal, as you just noted. If there are 50, state trial courts, and there are only 40 state courts of appeal, that means at least 10 states don't have courts of appeal. Those states will go straight to their own Supreme Court. Those are probably the smaller states. You can imagine a state like Texas, or a state like California, or a state like, New York, they're gonna have, courts of appeal. Go to Idaho, you go, well, we got 2 people, why do we need another court, There are 52 state Supreme Courts. Now this is a test question. How many state Supreme Courts are there in the United States? And the answer is what? 52. You'd go, wait a minute, where'd the extra 2 come from, right? You'd think each state has 1 Supreme Court. There are 50 states, 50 times 1, that's the first number you know how to multiply is 1 as a little boy. You go, hey, 50 times 1 is what? 50. Yeah, that'd be correct, except for there are 2 states with 2 Supreme Courts. Texas and Oklahoma. We are one of 2 states, Texas and Oklahoma, the great state of Texas, has 2 Supreme Courts. 1 Supreme Court is for civil cases, and the other Supreme Court is for criminal cases. Which one would you rather be a judge on if you were in the Supreme Court? Why? Because criminals are scary. That's scary. You're talking death penalty there, right? We're talking people could look at you and go, I'm going to kill you if you and you're like, you're sentenced to death. You're, oh yeah, I'm coming to get you, and trying to jump over that's scary, right? You don't want that. I would think about that if I was a judge. I'd be like, I'm going to my chambers. I'll see you later. You're dealing. Look, I had a buddy. He was on a jury in L.A. and it was a gang shooting, and he's in there. He grew a beard. He was in a disguise. Yeah, he's like, and because people come in and they could watch the trial, and all these gang members are coming in watching. He's like, oh my God, man, we better watch what we. And it was, by the way, it was his reason. He's a logic professor, my guy, and he convinced the jury they were gonna acquit. That means they were gonna find the defendant not guilty, and he convinced the jury that no, he was the one who did it. Because he's a logic professor, and he's like drew it out, all diagrammed it. They're like, oh my God, yeah, you're right, he did do it. And sure enough, now this guy's whole guilt or not guilty, not innocence, but getting off for murder, was on this guy's hands. And so yeah, I remember, yeah, he was so stressed. So you go, would you rather be a criminal or a civil? Of course, in the civil, you're like, the kids are going, I just want to be with daddy. And you're like, well, mom won the case. He gets you only once a month, And they're like, and the dad's going, oh. And you're, wrecking people. You want that one? I'm just joking, of course. It's a hard job. That's what I'm trying to say, is they're both very difficult. Well, anyway, the question on the test, if there would be one, and there will be one, which states have more than 1 Supreme Court? That would be Texas and Oklahoma, and you'd be able to divide that up. All right? I talked about how the Democrats during this election have argued that they'd like to, after it's all said and done, once they win, this is all predicated on if they win, okay? They have to win, and they have to win the Senate, and they have to win the presidency, right? That they would like to admit other states into the Union and turn DC into a state, okay? Now, constitutionally, this is, we open up our Constitution here. Not a long document, but the book sure makes it look like it. we'll talk a little bit more about the Supreme Court later on, because in the Constitution, because I want to talk about treason and all that stuff. But we, as far as today's lecture is fun, I just want to talk about this, and then we'll let you go. In Article 4, Section 3, it says new states may be admitted by Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other states. So that means like Houston can't become its own state, okay? Unless, of course, it says without the consent of the legislature of the state. So the state would have to allow that to happen. So Houston can't just go, guess what? Texas, we're becoming our own state. We don't like you anymore. Okay? The Texas legislature would actually have to allow that to happen, okay? And you cannot create two states into one state. They can't just merge. All right? So North Dakota and South Dakota can't just say, hey, we're going to do this without the consent of their own Congresses. But then Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. If a state wants to, or I should say a territory wants to become a state, let's take Puerto Rico, for example. If they want to become a state, Congress can put up some conditions. And they've done so in the past. So, for example, when Utah wanted to become a state, one of the conditions was you got to get rid of that barbaric practice of polygamy. Okay, because you know what polygamy is? Polygamy is having more than one wife. Bigamy is having two wives, two wives. Polygamy, meaning having many wives, right? Monogamy, having one, all right? And so America at this time was trying to get rid of what was called the twin relics of barbarism. In fact, I think I should test you on this one. The twin relics of barbarism. One relic of barbarism was slavery, and the other one was polygamy, okay? They believed that these were the twin relics, the things that were left over from barbarism. And the Mormons practiced polygamy. That's why Utah's filled. Okay, so Mormonism started in Missouri-ish. Actually, I think it started in New York, where their leader, Joseph Smith, allegedly found some gold plates in the hills of Cumorah and was visited by an angel named Moroni, and he gave him these goggles called the Urim and the Thummim. And anyway, so he creates this religion, and as part of this new religion, he teaches that it's okay and preferred for them to have more than one wife, okay? So Joseph Smith had several wives. Well, anyway, Joseph Smith gets arrested, gets eventually tarred and feathered, and really, he's killed. But Brigham Young moves a bunch of Mormons out to Utah, and they set up camp out there, and that's why Brigham Young University is in Utah. If you ever heard of BYU, have you heard of BYU? That's a Mormon college. Okay. Anyway, and so one of the things they believed was that polygamy is okay, and they practiced polygamy. And there's a famous case, Supreme Court case called United States v. Reynolds, or is it Reynolds v. the United States? I think it's United States v. Reynolds because he was accused of polygamy, right? So it must be the United States v. Reynolds. Anyway, and so he was found guilty of polygamy and as a federal crime. Why was it tried in the federal court? Well, because Utah was a territory, not a state, so they didn't have their own state courts. And if they did, they probably would have been corrupted because they all practiced polygamy, And so, okay, so one of the conditions to become a state for Utah, and they did want to become a state, was what? Get rid of that relic of barbarism. Yeah, you're correct. So that's one of the things that they can do. So to become a state, they could actually do that. The Congress sets conditions, and then they vote. Once these conditions are met, first of all, the territory has to want to become a a state. So Puerto Rico, does Puerto Rico want to become a state? They do? You're saying yes.
Actually.
I don't know. I think there's a divide in Puerto Rico about this. Like, some people are like, no, we like our sovereignty. They like the notion of being their own, kind of their own government. And they get the best of both worlds. They get the protection of the United States, and they somehow get the sovereignty of their own rule. But they don't get representation in Congress. And so they have no real choice over, major laws of the United States government that do, and they are a territory of ours, so they do fall under federal law. So anyway, once they petition for that, they decide they want to, Congress gives them some conditions. Once they meet those conditions, and Congress votes, there's a divide over whether it's 2/3 or simple majority. It's a simple majority in the Senate, if I'm correct, and that's all it takes to make a state a state. But once it gets that, then you have to get it back to the president, and the president can sign that, okay? And once the president signs it, now it has been denied on certain occasions by the presidency. So it's not just the Congress. All right? But what happens once they become a state? Well, first they have to ratify their own constitution, their new state constitution, which has to fall under, by the way, that's part of what Congress looks at, is does their constitution jive with the American Constitution? Would it be considered constitutional under our couldn't have like all sorts of discriminatory stuff in there. It actually has to fit. All right, and then they get 2 senators, and then they get as many representatives as their population allows. And that is a way to get power. Like, that's what we're talking about. And that's why they want to do it in DC. Now, the District of Columbia is not supposed to be a state, but they're trying to make it one. To get 2 more senators. And that's why their license plate, what does the license plate say in DC? Taxation without representation. Because they live in DC, but they don't have state representatives because they are not a what? They are a district. That's correct. Excellent. Excellent. All right, with that, I think that's all good and well. We could hit pause, play, or stop and